Good morning.
Good morning.
Good morning.
Good morning. So we have now our case that is set for Zoom argument today on Monday, May 23rd. Case number C-210145, Jared B. Chamberlain, Special Administrator of the Estate of Isaac Harrell versus Ohio Department of Job and Family Services. If council can please identify themselves and their readiness to proceed.
Good morning, Your Honor. My name is Amy Bachman. I represent Mr. Chamberlain, and I am ready to proceed.
Thank you.
Becky Thomas on behalf of the department, also ready to proceed. Thank you.
Okay, thank you. Attorney Bachman, would you like to reserve time?
Yes, Your Honor. 4 minutes, please.
All right, and you can start when you're ready.
Thank you. Good morning, Your Honors. May it please the court. Again, my name is Amy Bachman, and I represent Jared Chamberlain, Special Administrator of the Estate of Isaac Harrell. This appeal is before the court this morning because Isaac Harrell was denied long-term care Medicaid due to a resource which had no countable value. The primary issue before the court this morning is whether the lower court erred when it upheld the administrative decision denying Mr. Harrell's long-term care Medicaid application because he did not own available resources that were over the eligibility limit. The lower court determined that the administrative decision issued by ODJFS, which upheld the Medicaid denial, was proper, and it agreed with ODJFS, finding that Mr. Harrell did own a countable resource, which put him over the allowable limit. Mr. Chamberlain, here today, through me on behalf of Mr. Harrell, maintains that the resource in question, which was a piece of real property located in Laurel, Mississippi, was not a countable resource because the cash value of this alleged resource was not available to him during the time period in question. Mr. Chamberlain requests that the court overturn the trial court's decision and remand this matter back to ODJFS to reopen the application for further consideration.
It's really,
Medicaid program.
What's really
Sure.
troubling me when I went over your briefing is the fact that I did not see you address our Cohen case at all. And I was wondering if you could address why your case is not controlled by our decision in Cohen.
Sure. This case, so I was going to address that this morning. This case is similar to that case in some respects, and it's different in some. There is a decision. Ms. Thomas and I were actually here approximately a year ago arguing that case. And that case is similar in that it dealt with a piece of property, 2 pieces of property, actually. They were non-inhabited. They were at the back end of a lake. There was an easement to those properties. They had been listed for some period of time, couldn't sell, and ultimately she gave those properties away. That's how she became eligible. In this case, the facts are slightly different. The facts are different because this was actually the property where Mr. Harrell's home was in Laurel, Mississippi. In his opinion in Cowen, Judge Bergeron actually found that the OAC previously contained a provision to allow for the exemption of real property as long as the property continued to be listed for sale at an amount that was equal to the market value determined by the auditor or another appropriate source. This section of the OAC, which was 5160:1-3-05.1 subsection C6A, was actually repealed in August 2016, which was a month before Mr. Harrell's property hit the market in September of 2016.
But it was after he applied.
Correct. He didn't apply until February of 2017, and he had been private pay prior to that time. Interestingly, about a month ago, on April 1st, 2022, the OAC restored that section that had been previously repealed. It again allows for the exclusion of property that has not been sold as long as it's listed continuously and there's proof that there's issues that are affecting the fair market value.
Counsel, are you arguing that that's retroactive?
No, I'm not arguing that it's retroactive. Obviously, the policy was repealed in August 2016, and it didn't come back into place until April of 2022. But I think what I am arguing is that public policy has shown, and Cowan has shown, and several other cases that Ms. Thomas and I have argued have shown that this was obviously a problem. That's why they put it back into place now. And so for us to exclude Mr. Harrell's property would be appropriate, because if it was done today, it would be appropriate. If it was done August 1st, 2016, it was appropriate. Unfortunately, for reasons that I cannot explain, that was repealed, and there were, a number of people who were unable to have their properties excluded while they were properly listed for sale, as the regulation states today. If you look at Judge Bergeron's opinion in Cowan, it tends to indicate that, yes, this would have been excludable, but for the fact that this was repealed. And again, it was, when it was reenacted last month in April, the language is substantially similar. It's almost identical to what it stated.
So just so that I understand what that means, that this is basically a reasonable efforts exclusion, right? That's been put in place to say that the resource is not countable if the person is making reasonable efforts to sell it.
Correct, Your Honor. So it has to be listed with a licensed real estate agent or other appropriate entity on like a multiple listing service or a public, offered for sale on a public forum. It has to be listed consistently during the period of time in question, and it has to be listed for a fair market value. And in this case,
but you're arguing that you have like a 20-day argument that you raised, right? That the property is not sold within 20 days, but that's not this exclusion.
That's not this exclusion. That's actually a federal exclusion. And interestingly enough, so the 20-day argument, to go back for a second, Medicaid regulations for exclusions of property mirror the Social Security regulations in federal regulations. And federal regulations provide that the Medicaid home exemption under Title 20 CFR 416.12.12, the home includes the dwelling in which the person lives on and the land on which it's located and related outbuildings. And hang on one second, I can tell you exactly, because I just looked at this while I was waiting. It's actually 20 CFR 416.1201C, which defines non-liquid resources. And non-liquid resources are property which is not cash and which cannot be converted to cash in 20 days. Examples of this include things like buildings, land, automobiles, and those regulations further provide for the valuation of a non-liquid resource, such as a piece of property. 20 CFR 416.1201C21 provides that a non-liquid resource's value is its equity value, which is the price that the item can reasonably be expected to sell for on the open market in a particular geographic area involved. And the facts of this case demonstrate that for the relevant time period, and that time period was September 2016 to September 2017, it was just shy of 2 weeks of a year. The property at issue had a fair market value of $0 because there was nobody who came forward for a full year. And in fact, during the course of the year, the facts of this case show, and it's in the record, that Mr. Harrell, Isaac Harrell, who was actually incompetent and had a legal guardian, his son Marcus gave the real estate agent permission to drop the price. It was originally listed for $149,000. And then later, I think it was dropped to $129,000, and it ultimately sold for $100,000 after it had been on the market for a year. So the argument that we would bring forth is that, until it actually sold, it didn't have a value. And even when it did, it wasn't the value that originally was put forth as the value assumed to be fair, i.e. the $149,000 that it was listed for in the first place. So
are you asking us to apply the 20 CFR 416.1201 to Ohio Medicaid in the Medicaid context? Is that what you're asking us to do?
Essentially, yes, Your Honor, because
but that is a direct violation of what Cohen said, right?
Well, I don't believe that it is, because I think in this instance, this is different because the property itself here was actually the dwelling. It wasn't a piece of vacant land. And so there are Ohio regulations which deal with the sale of the home. And now that the old regulation, which Judge Bergeron indicated had been repealed, has been brought into place, it's our position that, hey, wait, this case is still out there for reasons really outside of anyone's control. It's kind of been moving back and forth through the system since I think 2017 or 2018. And so, if this had happened today, Mr. Harrell could very easily exclude this piece of property because it's been listed, for the period of time that's in question that he was requesting.
You're saying the distinction now is the fact that it was his residence, but if it happened today, then Ms. Cohen would have been able to also exclude.
And I don't disagree with you, Your Honor.
It doesn't matter what kind of property it is.
Well, there is a distinction in the OAC for treatment of the home versus just treatment of land. Because with treatment of the home, you can also exclude it in other ways, such as an intent to return home. Obviously, the properties in Ms. Cohen's case, she couldn't ever exclude because she didn't live there. There was nothing there. So in this instance, I think for a time period, and it was a time period before I got this case, I think he did exclude the home with an intent to return home. He was also private pay. He actually had been in the facility since, I believe, October 2013. So he had an extensive time that he was there and that he was under the care of his son before the home actually went on the market and sold. And I think, the hope was that he could go home eventually, but when it became clear that he couldn't, then they had to sell it and liquidate it in order to, get it out of the way.
Counsel, you have 1 minute left.
Okay, thank you. So it's our position that with both the federal and the Ohio Medicaid regulations, that there is the means to exclude a property such as this one. It seems clear in this case that Ohio lawmakers and CMS understood that the changes that were made in August 2016 to the OAC didn't work. Because they reversed the action and they reinstated this section to the OAC last month. And unfortunately, as Judge Krause mentioned, there are many others, such as Mary Cowan, who were denied benefits when they were otherwise eligible as elderly, infirm, poor, people who had properties that just languished on the market during an ugly time for home sales. Interestingly enough, in today's market, Laurel, Mississippi property is a hot commodity. If you're familiar with HGTV, Ben and Aaron Napier have their hometown show that's based there. They flip properties frequently, and we're in a housing market boom for the most part. So it could be completely different today, but back in 2016 and 2017, unfortunately, that was not the case for Mr. Harrell, and this property sat even though he did everything right. So, we would just ask that the court take that into consideration and rule in our favor and return this back to the agency for a remand. Thank you.
Thank you. Attorney Thomas, good morning again.
Good morning. Thank you. Becky Thomas on behalf of the Ohio Department of Job and Family Services. So I think what Mr. Chamberlain is now asking the court to do, which is not in the briefs, is to apply a rule that was not in effect at the time to this case. That's not something that the court can do. It can't just apply a rule that was not in effect during the time that mattered. That would mean that the court would be calling lower decisions wrong, even though they were correct based on the law at the time. So the court should not be reversing decisions that were correct. I think that's elementary. And this is actually a little bit in conflict with Mr. Chamberlain's actual argument in the briefs, which is that the definition of resources in state and federal law showed that this property should not have been counted. Without any rule about excluding property not sold, Mr. Chamberlain's argument and Mr. Harrell's below said that this definition of resources, because I hadn't sold it yet, I didn't have the money hadn't changed hands, is the way it's put in the briefs. Because money hadn't changed hands, I didn't have access to the cash, and so it couldn't be a countable resource. That's the argument that was made in the briefs. And the 20-day argument, I just want to point out briefly, I don't believe was made at this level. I think it was only made at the lower levels and was abandoned at this level.
Seems like
So
what I'm hearing now is that there's an argument that there's this reasonable efforts exclusion somehow should be applying. That they were engaged in reasonable efforts to sell the property, and that should be taken into consideration in determining if it's countable.
I don't believe that phrase appears in Mr. Chamberlain's briefs. You could say that a few times when there's a mention that he had listed it for sale and nobody came forward, that's some kind of suggestion that there were good faith efforts being made to sell. But here's what we know from the record, and this is all we know from the record about that. It sold for $100,000 in September of 2017, and we are supposed to believe it was not worth even $2,000 for the 12 months preceding, with no evidence. We don't know there was a flood in the basement. We don't know there was a sinkhole in the front yard. We don't know anything like that that would make it unsaleable. We also know that it was listed for sale at $149,000 at first and stayed there for 7 months. If it sold for $100,000, which we might presume is going to be around the fair market value, no wonder it didn't sell for those 7 months. And then it was dropped to $129,000 in April of 2017. This is in the record. I can even give you of the administrative appeal record. That's the first part, page 37. The listing agreement shows that it was listed for $149,000, and on page 189 of that same record, there's an email showing authority to reduce the price to $129,000. I don't know, we don't know when it was reduced beyond that, if it ever was reduced. So my colleague admitted that the standard under this reasonable efforts or good faith efforts policy would be that you listed at the fair market value. That's a requirement in there. We have no idea if that happened. We have no clue. What we know is it was listed way over $100,000 and then somewhat over $100,000. And the next thing we know is that it sold for $100,000 in September 2017. The hearing is where you bring your evidence. That's where you come and you say, here's my expert saying that this property is worthless. We can't sell it no matter what we do. Or it's not worth $2,000 or whatever. That's what the hearing is for. It's for evidence. There was nothing presented at the hearing about the value of this house. Because of a procedural quirk in this case, by the time of the hearing, the house had already sold. And that's because there was a remand, because the first reason that it was denied was found to be incorrect and it was sent back. So by the time it got here to hearing, it had already sold. So the agency said, well, we have $100,000. It probably didn't sell for more than it was worth. Maybe it sold for less than it was worth, but it sold for $100,000. So we're going to assume that's the value of the house. And no evidence was brought at all to say otherwise.
So just so I understand though, the new regulations that I don't believe are being argued to apply retroactively. I mean, that's a whole issue. They weren't in place at the time of this case, but those regulations would require some sort of demonstration of reasonable efforts to sell, right?
Yes.
And what you're saying is that even if we were to apply the new regulations, there was no such demonstration in the record below.
Right. That rule puts the burden on the applicant to show this and to provide documentation of the fact that it was listed at fair market value and that, or that there was some reason why I couldn't sell, or that reasonable offers were not refused. None of that was provided, not one bit of any of that. All we have is argument saying that, well, because it didn't sell, therefore it couldn't sell. That's not right.
I thought what they were really arguing though was not really this reasonable efforts exclusion. It was the 20-day thing, saying that, well, it didn't sell in 20 days, therefore it's not a resource. It can't be countable. I thought that was the argument below.
That was the argument below.
Right.
That's right. This reasonable efforts thing is, I think today is the first time I've heard it.
Well, I mean, it's based on the new regulation, right?
Right, which wasn't in effect. So in fact, it kind of highlights the fact that it wasn't in effect. I don't know how it helps Mr. Chamberlain at all to show that rule is back in effect. And it's not exactly the same, but it's mostly the same. And in fact, Mr. Chamberlain's argument in this court, in the briefs, which is what we responded to and what I prepared for today, what's in the briefs, is that the definition of resources tells you it can't be included. This real property could not be counted because it's not even a resource at all. But here's the definition of resources: cash, other liquid assets, personal property, and real property. The rule contemplates that some things that are not yet sold are resources. Otherwise, it would just say cash. Mr. Chamberlain says multiple times in his briefs, until money has changed hands, you don't have a resource, but that can't be right. Because first of all, nothing would count except cash under that theory. And second of all, once you sell a resource, you don't own it anymore. And Mr. Chamberlain admits ownership is the first element of a resource being countable against you in a Medicaid application. So there's no way that theory works. It's just not true. Personal property and real property, just like cash and other non-liquid and other liquid assets, they're all types of resources that can be counted if they're not excluded by a rule, and this was not. And if the person owns it, the applicant owns it, that's admitted. Has the legal right to sell it, that's admitted expressly on page 24 of Mr. Chamberlain's first brief. And if you're not legally prohibited from using it for your support and maintenance, that's what actually happened. He did sell it and he did use it for support and maintenance. He spent it down the first month of this, right after it got sold, presumably on past expenses. I don't really know for sure, but at any rate, it would be spent on himself. That's how come it would not count as an improper transfer. And in fact, not only is the home here not excluded by any rule, it's specifically included by a rule that was in effect then. A copy of it is in the record. That's 05.13 at the time, C2, says that the home principal place of residence counts as a resource if there's no intent to return. And it would be the fair market value minus any encumbrances on the property. I don't know of any encumbrances on the property, but I sure don't think there's $98,000 worth of encumbrances on the property. And there's been no argument about that. Maybe you take off the $9,000 or $10,000 that he ended up with after the sale and associated costs. That's in the record on the settlement statement. So let's say $90,000 is what he ended up with. That's way more than $2,000. And it strains credulity to suggest that this house can be said to be worth less than $2,000 during the year, especially when it was listed at such a higher amount than it, for all we know, for the whole year than it sold for. So,
Ms. Thomas,
yes.
Opposing counsel attempted to distinguish Cowan. Can you address her argument, please?
Sure. I don't think there's any difference between Cowan in this case. The argument, if you look at the briefs filed by the appellant in both cases, you're going to see a whole lot of similar words. And probably the same is true of my response brief, because we argued the same issue. Can something that hasn't been sold yet be counted as a resource? The obvious answer is yes. That's what the rule says. Even the federal rule that Mr. Chamberlain relies on so much and relied on last year, in that case, Ms. Cowan, that rule, the federal SSI rule, also says that that those four kinds of things can be resources, including things that aren't sold yet. Otherwise, it wouldn't be a real property or personal property to you. And if you own it, have the legal right to sell it and have not legally prohibited from using it. That same issue is what's there in Cowan. I want to say one thing about what Judge Krause brought up. So it is true that the SSI eligibility rules for regular benefits are relevant to Ohio Medicaid. And I apologize for this, we had not briefed that very well in the first years after the big change in 2016. So we have said some things in our briefs in the past that we now regret. But it doesn't change the outcome. It's dicta in Cowan because we do meet those requirements. We are the same. If you look at the definition of resources in 1201 and the definition in Ohio Administrative Code at the time, they're virtually identical. And the one thing that the federal regulation does is it elaborates on what could means. When you say could sell or could access or could liquidate. Could means you have the legal right, authority, or power to liquidate it. Mr. Chamberlain admits that Mr. Harrell had the legal right. Right, authority, or power. He admits one of those things, you're done. The other two are already admitted and actually happened. He owned it. He had the legal right to sell it. He did sell it. He had the legal right to use it for his maintenance and support, and he did that. The legal ability to do something doesn't mean you actually are doing it or will do it or ever will do it. It means you could, and it wouldn't be unlawful if you did it. So the legal ability to sell something doesn't mean you will sell it or you have sold it. Just like when I got my license to practice law, I was then legally able to practice law. Didn't mean I had a client yet. It just meant I have a license. It's not under suspension. I'm not impaired. It wouldn't be unlawful if I practiced law. When you get a driver's license, you have the legal ability to drive a car. That just means it wouldn't be unlawful if you drove a car. It doesn't mean you have a car and or you're driving right now. It just means you have a legal ability. That's a separate concept from an actual ability, which might depend on practical circumstances. And as the Cowan decision said last year, the plain meaning of legal ability to access precludes an exemption for impracticability. And that's because legal ability is different from an actual ability.
So they're just out of luck by virtue of timing, Cowan and this particular case, because now it would not be a countable resource.
I don't know that. We don't have the information. It was never established that it was listed at fair market value for that year. And in fact, I would argue we had information suggesting it absolutely was not listed for a large part of that year at fair market value. At the very least, we know that. We don't know that there were not any reasonable offers that were not refused. We don't know we don't know any other details about it, and none were presented to my knowledge beyond what we've already talked about today. And so even if that rule had been in effect, it wouldn't matter, but what wasn't in effect? And that's a thing that states, even 1634 states, which is what Ohio became in 2016 with CMS's approval, I might add. That's judicially noticeable. You can look that up, look up state Medicaid plans and look up Ohio on the website. You can find it. It was in effect 8/1/2016. CMS's approval is right there. States can choose whether to have this exclusion for unsold property if it wants to, because states can be more liberal than the SSI regs, but they don't have to be. And so Ohio did not have that rule for a few years. It has now put it back into effect for policy decisions that the agency is permitted to make. I don't know how you.
Counsel, you have 1 minute.
Thank you. I think I've said everything I can say at this point, and so we asked the court to affirm based on Cowan because that was just a year ago and it was correctly decided. Thank you.
Thank you. Attorney Bogman?
Thank you, Your Honor. So I'd like to distinguish quickly. Mr. Chamberlain is not alleging that this wasn't a resource. He's alleging that it was not a countable resource because during the time period in question, without something to substantiate the value, i.e. somebody coming forward and paying for it, there's no fair market value to it. And that's the argument that I made earlier from 416-1201C for the non-liquid.
So the house had no value until somebody made an offer, is your argument?
Correct, because there were no buyers that were coming forward. There were no buyers that were available. So essentially, you cannot liquidate. I go back to Kinsey, which I cited in my brief. Kinsey versus ODJFS is a Logan County case. And in that case, Judge Bragg ruled that the only right until somebody came forward was the right to offer to sell the property. There was no right to actually sell the property because going back to basic principles of contract law, offer plus acceptance equals the contract. You can have the right to offer this to sell the house, but you don't have a right to sell the house until you have someone who's actually willing, ready, and available to buy the house. So there's no way to get the cash value out of the property until such time as you have somebody who comes forward and who's willing to pay for it. Mr. Harrell could have this house, and this is why this regulation was in place before August 2016, and this is why it's back in place now. Mr. Harrell puts it on the market, and I would argue the opposite of what Ms. Thomas says. a licensed real estate agent is not going to put a piece of property on the market for an exorbitant value in 2016 in Laurel, Mississippi, in that market. Today, that's one thing.
She's arguing that there was no evidence presented below on this whole reasonable efforts exclusion that you're trying to argue right now.
Well, I think there was evidence that was presented because it was listed for sale when it wasn't selling at the price that everybody thought was reasonable, and presumably the licensed real estate area or agent who practices or works in the area that the home was located is the expert and would know and would say, okay, I think this house is valued at $149,000. Let's start it there.
Do we
When
know
Marcus
if there were
Harrell-
offers that were made that were rejected? Do we know that?
No, there was nothing. There was no evidence that was presented during the time period. And to my knowledge, there was nothing. In fact, that's why Marcus Harrell agreed to drop the listing price to hopefully, I think his email even says this should work to your benefit, to the real estate agent, because there was nothing that was happening on it. When he was finally presented with the $100,000 offer, he took it because that was the first offer he'd had in a year. And so I think contrary to what Ms. Thomas is saying, this goes to show that it didn't have the value that the experts said it did. It actually had a lower value. And during that time period, it sat there and they lowered the price and they tried to work with things, but it wasn't, it wasn't something that just was able to sell, and it sure wasn't able to sell quickly. And that's where the 20-day piece comes in. With this being non-liquid, of course he owned the piece of property. And of course he would owe whatever the money is. And what happens is once the property sells, he goes off of Medicaid, he spends down the money so that he's under the resource limit. And then he gets back on Medicaid and is able to be reapproved with the property having been sold. But in an instance like this, why prejudice somebody like Mr. Harrell, who is otherwise eligible? He's old, he's infirm because he's in a long-term care nursing facility. He's poor and he doesn't have anything. I mean, that's why Jared Chamberlain is the special administrator of his estate, because there was nothing. He died intestate. There was no will. There was nothing left. So
is the 20-day piece different than the new regulation reasonable efforts to sell idea? Those two separate concepts?
I think it's a similar concept. I mean, one's federal and one is state regulation. So I think the reasonable efforts comes more under the current state regulation, but the federal regulation was there the whole time. And it's our position that this was wrong to begin with. It was wrong all the way through. If you look at Ohio's regulations, resources mean cash and real property an individual has an ownership interest in, has the legal ability to access in order to convert to cash, and is not legally prohibited from using for support and maintenance. It's not an either or scenario, it's an and scenario. You have to have all three. And in this instance, there is the ownership interest and there is the legal ability to access, but where's the in order to convert it to cash? You can't convert it to cash until you actually sell it. And that's why I keep going back to the Kinsey opinion, where Judge Bragg said, you can't do it. All you have is the right to offer to sell it. And that's exactly what happened here. He offered to sell, Marcus Harrell, for his dad, offered to sell the property. But until the property sold, Marcus and Isaac were in an infinite loop where Isaac was, he had two choices. He could give it away and get on and take a restricted restriction for it, for the improper transfer, or he could sit and wait. And that's what happened. He sat and he waited. And when he came off of the spend down, what's left now is what was left over from that time period where he wasn't able to get on. He was private pay up until they applied in February of 2017. And then there's a 9-month time period that's unaccounted for because he wasn't able to get on because of the sale of this property. And it's our position that yes, he owned a resource. Yes, it was available in the sense that it was available to be sold, but it wasn't countable because it was unavailable value-wise, if that makes sense.
Thank you, counsel. Thank you.
Thank you.
Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision, and we wish you both a wonderful afternoon.
Thank you, Your
Thank you,
Honor.
same to you.
And that concludes our hearing.